Nearly 4 years ago, Democratic state lawmakers updated New York's gun control laws following a racially motivated mass shooting in Buffalo. The tougher rules included requiring New Yorkers interested in a permit to carry a concealed handgun to have their social media accounts reviewed to assess an applicant's character and conduct. But it does not appear that this aspect of the law will be implemented as the result of an agreement filed recently in federal court stemming from a legal challenge to the 2022 law. For more on this story, we're joined in the Capitol Press Room by Adam Scott Want, an associate professor of public policy with the John Jay College of Criminal Justice. Thanks for making the time, Professor.
David, thank you for inviting me to talk with you.
Well, less than a month after the mass shooting at the Buffalo grocery store that I mentioned at the top, state lawmakers had written, passed, and signed into law stricter gun control measures, which included new steps for getting a concealed carry permit. In addition to character references, applicants would be required to flag any current and former social media accounts from the last 3 years for local officials to review. At the time, you raised concerns about the slippery slope of a requirement like this. Can you expand on the potential shortcomings, both from a logistical perspective as well as, our constitutional rights?
Yeah, I think it goes both ways, and I think that you've summarized a lot of it. When New York first put this law into effect, a lot of us took a look at it and questioned whether or not it went too far, whether or not we were initiating a slippery slope into what we looked at when we were determining whether or not to issue somebody a concealed carry permit. I think there's no doubt that we want people with concealed carry permits being of mental and good mind, good sound mind. I think there's no doubt that there should be some character component to it. And I certainly don't object to character reference letters for a concealed carry permit. But when it comes to being forced to disclose all of your current and social media profiles, first of all, this raised some First Amendment issues for us, and it raised some First Amendment issues for us because we were really uncomfortable with having to disclose accounts that we have the right to have and the freedom to express ourselves. And it was the type of case that was on the line. And we didn't want to go any further and cross over that border, that slippery slope, where the government starts making requests like, all right, well, this was a private account, but we need to see into the private account. And we weren't really sure where the slippery slope would fall. And immediately it brought all these First Amendment constitutional issues to us where we were trying to figure out, is this an overreach of government? And in my opinion, analyzing it at the time, the answer was yes, it was an overreach of government. At the same time, there's a technical component to it where not every sheriff or police agency that investigates somebody are going to use the same standards. And there was really no way for an individual investigator to understand what the standards were to pass or fail once they got access to somebody's social media profile. And on top of that, the standards themselves were a bit unclear because many of us have both personal social media profiles and business social media profiles. So it was really we were really unsure what needed to be reported and what didn't need to be reported. So we were all pretty unhappy, with this new law, even though we agree that there needs to be a good character and mental fitness for somebody to, hold a concealed firearm in New York City or New York State.
Well, is there a difference in terms of the constitutional questions or logistical questions between requiring someone to hand over social media accounts or a local entity that's responsible for issuing permits to do its own proactive digging to say, okay, David Lombardo, what's out there about him? Let's Google David Lombardo in Saratoga Springs so we don't find the drummer from Slayer, but we do find the guy from, upstate New York who's looking for a permit. Is that type of activity more permissible, or does that head down the same sort of rabbit
It,
hole?
it, it does not. David, look, if you're going to apply for a concealed carry permit and you're going to be going through a character and mental fitness investigation, I have not a problem in the world with the investigator going onto Google, going onto open source investigation tools. I don't have a problem with them looking at what you leave out there publicly. Where the problem comes in is the mandatory disclosure in order to apply in the first place. And not only the mandatory disclosure to government, but it also would give government a mapping of all your different social media accounts on all the different platforms. And many of us have social media accounts that are not under our name and that are business related or theme related that we don't want linked back to us. And the mandate was just very unclear to begin with. So, yeah, power to the investigators. If an investigator is going to go out and do a good investigation, and if they find things that somebody is publicly putting out there that makes us question their character or their mental stability, that should absolutely be allowed. The problem came in with the mandate of reporting by government, and that's where a lot of us started to take issue.
And the reason this is not going to be implemented is, as I mentioned at the top, the result of a settlement from a lawsuit, one of a number of lawsuits that were filed in the immediate aftermath of this law taking effect. What is the practical effect, though, of the state attorney general's office entering into this agreement? Does that have the effect of basically going into New York state law with a black Sharpie and striking it out? Or is there some reason to believe that there could be a future where this law might be implemented under a different attorney general, for example? I mean, what could happen or will happen?
I would call this a stalemate that should be resolved by the legislature. I think at this point, what we have happening is the AG's office agreeing that they'll be permanently enjoined from pursuing any of these social media disclosures. It's unclear to me at this time whether or not it will be removed from the application if it's legally required to be there. The settlement may simply, not cause any negative results when somebody leaves that information off the application, right? So the settlement is good. I am glad that the state has understood that this behavior does rub up against constitutional issues of significant concern, even in a state where we want gun control, uniformly throughout the state. This goes a little bit too far, but it leaves a hole that should be filled by the legislature, adjusting the law so that it is what it should be and enforced in the full.
Well, I want to follow up on what the law or the language should look like in the future. But first, let me reintroduce you. For listeners just joining us, this is WCNY's The Capitol Press Room, and we're speaking with Adam Scott Want, an associate professor of public policy with the John Jay College of Criminal Justice. So, from your perspective, is the best path forward for the legislature just to repeal the offending language, or would you encourage them to take another stab at this to try to walk this narrow tightrope, so to speak, to incorporate our online presences more broadly into permitting moving forward?
I think what I would have preferred and what could still happen is that the legislature apply a standard of investigation that is uniform throughout different, counties in New York
Sure.
State. If the legislation had things the investigator should take into effect or take into account, if there were at least minimal standards that the investigator should look at, I would have no problem with that, including social media. And I think that certain language could be removed from the current legislation. And at the same time, they could add guidance either in the form of legislative notes or right within the legislation to make it clear that the investigator should spend time investigating the online persona of the person to see if anything, comes up of concern. I think that there's a middle ground that could be codified, and I'm all favor of that.
One of the things that I noted in a discussion about this law was this idea that there was no historical precedent to require people to disclose social media accounts, which is kind of in keeping with the tone and tenor we've heard from the U.S. Supreme Court when they've been narrowing gun control laws. Does that idea of precedent, though, really restrict the ability to incorporate online activity at all, given the fact that 250 years ago there was no internet, obviously?
You've hit the nail on the head when it comes to one of the significant conflicts we're facing here in 2026, or at least this part of the century.
Sure.
Courts run and love to talk about precedent. There is no real long history of people having social media. Social media has really only taken root in the past 2 decades or so. I reject the argument that there was no precedent, so we shouldn't do it, because there was no social media, to form precedent on a decade or two ago. I think when it comes to certain technology issues, we need to understand that we need to examine these with a fresh mind, putting them in context to 2026, and then see what's logical at that time.
So in addition to I mean, what I imagine is your day job, you also help law enforcement get trained on how to conduct searches on people through social media. So is there any sort of best practices that you would want to pass on to, well, what would be in New York, local law enforcement, some judges, and like county clerks' offices, this hodgepodge of people responsible for permitting? Any sort of best practices you'd want to pass on moving forward about how they should use the internet or social media searches more specifically to look into people?
Yeah, I think what's best to be said is that law enforcement investigators around the country have already recognized the relevance of open source intelligence, which is what it's called, which is social media investigations. We recognize the relevance, we recognize the power of it, recognize the value of it. But departments across the country do not provide uniform training at the level that you would expect them to. So while all police officers in the field have certain uniform training around the country, OSINT is not part of those standards, and it should become part of the standards. So my message wouldn't be to individual investigators or individual police officers. The message would be more towards command officials, commissioners, chiefs, and it would be look at the current literature that's out there on the lack of uniform training on OSINT within police departments and do better.
And has that been your experience when you are interacting with people, that there really is a variety of awareness and familiarity with best practices?
Yeah, so a 2024 survey that I ran for law enforcement showed that 99% of law enforcement felt that OSINT solved their cases more accurately and were of high value, yet only 20% received any formal training in it whatsoever. The investigators that are out there understand the value of this, but they're also not given the types of formal training structures that allow them to make the best use of this technology.
Well, lastly, this gun control measure from 2022, like most of the gun control measures that are passed in New York, are in response to shootings and generally come months, more likely weeks, after the tragedies. And I was impressed by the fact that you kind of called this out back at the time in 2022 when you described New York's law as being rushed. And I'm curious if you see a problem more broadly beyond just this law when lawmakers are trying to be so reactive to shootings.
There's no doubt in my mind that the worst legislation is quick reactive legislation. We have the need in the United States on a regular basis to have reactionary legislation when something goes wrong. However, that legislation is almost always rushed to get it out, and it very frequently needs to be adjusted. So there is this problem that we have on reactionary legislation. I like when we're proactive with our legislation, and an area that we are very proactive with is automated driving vehicles. It's a really good example that I give to people of good, solid, proactive legislation. But unfortunately, we don't do that more often. We should be doing that more often.
Well, we've been speaking with Adam Scott Want. He is an associate professor of public policy with the John Jay College of Criminal Justice. Adam, thank you so much for making the time. I really appreciate it.
David, thank you for reaching out, and I look forward to talking with you in the future.
Support for the Capitol Press Room is provided in part by the Lawsuit Reform Alliance of New York. Fraud and lawsuit abuse impact car insurance costs for New Yorkers. Reforms are being proposed to mitigate their impact. Information on these reforms is available at keepnewyorkaffordable.org.